program and SRM University for inviting me as a speaker to address this August gathering. And I want to know how many participants are there here online? Sir?
Sir, in total, we have about 60 participants, but they are slowly logging in. Right now, about 36 have logged in, sir.
Okay, 36. Out of the 60, how many non-law persons are there? Non-law teachers are also there?
Maybe one or two, sir.
One or two?
Maybe one or two. That also humanities professors who are teaching in law college only.
Oh, humanities only I'm asking.
Other than those who are teaching in law college only, but one or two, sir.
One or two, okay.
Yes, sir.
How many teachers are teaching out of 60? This corporate law, any idea?
I am sure it will be quite a few, sir. We don't have the exact statistics.
Roughly 10% or 10%?
Yes. Sir?
10% will be there?
More than that, sir. More than that, sir.
Corporate law.
Yes, sir.
Okay. Thank you. Anyhow, non-law persons are there. Non-corporate law teachers are there. So my topic is developments in corporate law. That is from the date of passing the first act till today. So, when we discuss company law or corporate law, before that we have to discuss what is law. Law is nothing but Sarma, he defined law as body of rules recognized and applied by the courts while administering justice to its citizens. So law is nothing but a body of rules. It is nothing but codified law or uncodified law. But these principles must be recognized by the courts. Even though it is passed in parliament, if courts, if they don't recognize, that is not law according to jurists. And these courts must recognize these principles and apply these principles while administering justice to its citizens. And broadly, these laws you can classify into pre-law, public law, and private law. Pre-law means Government of India Act 1909, 1919, all these come under pre-law. Public law means public law is that branch of law which defines the rights, powers, and duties of the state, and it also determines certain relationship between the state and its subjects. For example, constitutional law and administrative law, these two come under public law because these are defining the powers, duties, rights of the state and determine the relationship between the state and its subjects, fundamental rights, directive principles. And private law means it determines the relationship between two subjects inter-se, that is, two individuals in a country. And whether criminal law is a public law or not, that was a dilemma, that was a what you call controversial area. According to old jurists, criminal law was public law, but the modern jurists are saying that criminal law is also a private law, not public law. It is like Income Tax Act or tax laws. They are dealing with citizens by the government. Even though they are dealing by the government, old view was that public law, but modern view is it is private law. And law of contracts, law of torts, law of crime, all these come under private law. And this private law again classified into two types, substantive law and procedural law. Substantive law means it simply defines the rights and duties, rights and liabilities of an individual. For example, contracts, torts, all these rights and liabilities of an individual. And the other one is procedural law, rejectable law. Procedural law, rejectable law means it determines the what you call procedure. It determines the procedure to get the remedies. For example, procedure is now CRPC is there, Criminal Procedure Code, Bharatiya Nagarika Suraksha Samhita. Very, very difficult to remember this name. For us only it is difficult when foreign firms open, when they come, how they can pronounce all these sections, Bharatiya Nyaya Samhita, Bharatiya Nagarika Suraksha Samhita, and Bharatiya, what you call IPC also, they changed. And difficult for the teachers who are teaching these subjects now, how they are every time pronouncing these laws. Even for aviation law also, Bharatiya Udan, like that they said. And how foreigners, foreign countries, and inside total English, outside we are keeping Hindi title. That I don't know why they are keeping like this. It is causing inconvenience to particularly those who are residing in southern states. And northern people, no problem, they can. But foreigners tomorrow when they come, they are unable to pronounce our names. How they can pronounce these laws? CRPC, CPC, evidence, all these come under what you call procedural law. And now Companies Act is public law or private law. Companies Act is private law, whether it is substantive law or procedural law. It is both. It is substantive law and procedural law because it defines the rights and liabilities, duties of shareholders, company, everything. It also determines the procedure, NCLT, NCLT, all this it discussed. So company law is also substantive and procedural law both. Whether it is civil law or criminal law, Companies Act, it is both. Companies Act is civil law and criminal law because in case of violation of any provisions, some sections are prescribing imprisonment, some sections are prescribing what you call fine, some sections are prescribing monetary penalty. So it is both civil law and criminal law. It is both substantive and procedural law. And with this background, let us go to what you call our company law and corporate law. Before discussing Indian company law, we have to go through English law because even today, when we teach what you call any subject law of contracts, Indian Contract Act 1872, we discuss so many Latin maxims. Whole IPC is based on one Latin maxim called actus non facit trium nisi mensitria. The act alone does not constitute a crime unless it must be accompanied with a guilty mind. In law of contracts also we teach what you call ex turpi causa non oritur actio, ex dolo malo non oritur actio, like that, so many Latin maxims. In law of torts also, ubi just ibi remedium injurious and damnum, all these. And when we explain the case law in contracts or torts or IPC, first we teach English cases. Orr versus Tolson, Balfour versus Balfour, Ryland versus Fletcher. Why we are teaching English cases even today after getting independence 75, more than 75 years? And why we are teaching Latin maxims even today? Because Roman law is the basis for English law. English law is the basis for Indian law. At one time, till 1960s, 65, 68, Roman law was a compulsory subject. And even today, a teacher, if he wants to become a successful teacher, if he or she wants to understand the concepts of law, first of all, we have to go through Roman law. So many books are there on Roman law, and even foreign nations, Indian authors, both are there. We have to go through Roman law first to teach our laws. Even jurisprudence, when we teach ownership, first so many Latin maxims, animus, word called possendi, like that. So many Latin terms we teach first. And to majority students were failing. So all students requested Bar Council to remove the subject. They removed this Roman law from what you call our syllabus. And if you take our Indian Contract Act 1872, and this particular, before 1872, also citizens were there in the country, in India, Bharat, and they were entering into contracts. Then which law they were applying? Before 1872, when there was no codified law for contracts in India, in presidency towns, they were applying personal law of the defendant. Personal law means if the defendant was a Muslim, Muslim personal law. If the defendant was a Christian, Christian personal law. If the defendant was a Hindu, Hindu personal law they were applying. In presidency towns, Madras, Bombay, and Calcutta. In provincial towns, the courts were applying justice, equity, and good conscience. Equity principles they were applying. Equity means fairness. Equity means dharma. Dharma principles they were applying. Even today, these equity principles in several areas, in Transfer of Property Act, we are specifically, in fact, almost 50% equity principles only we are applying. And your quasi-contracts or quasi-contracts, they are based on equity principles, justice, equity, and good conscience. And these equity principles, dharma principles, they were applying in provincial towns. But courts were giving different judgments on same set of facts. Then Britishers thought better to give a codified law to these Indians. And they codified Indian Contract Act 1872. And if you read the preamble of the act, whereas it is expedient to consolidate and amend certain parts of the law relating to contract. They said Indian Contract Act consists of 266 sections, but this act is not exhaustive. So many areas, gaps are there left over. Then which reference to leftover portion, which law we have to follow? Our Indians ask the Britishers, follow our law. Our law means their law. Their law in England, even today, contracts is not codified. In England, even today, criminal law is not codified. They don't have English Penal Code, English Contracts Act. They are based on judgments of courts. That is Privy Council and House of Lords and Court of Appeal decisions they are following. And that's why even today, what you call, wherever our laws are silent, we are following English decisions. For example, in contracts, if you take, in company law also, if you take doctrine of indoor management, the teachers who are teaching doctrine of indoor management, which case law they are teaching? Royal British Bank versus Turkand. Ultra wires, even today we are teaching Ashbury Railway Carriage Company versus Ritchie. And why we are teaching English cases? Because with reference to these areas, our Companies Act is not exhaustive. This gap we are filling with English decisions. So even today, English case laws are important for us, and that's why we are teaching, because English law is the basis for Indian law, and Roman law is the basis for English law, and history of English company law. And with reference to English company law, government created corporations under Royal Charter or an Act of Parliament with the grant of monopoly over a specified territory. By passing Royal Charter, companies, the British company was creating, that is East India Company, which ruled the Indian government, India for 2 centuries. So that is the first one. East India Company was established in 1600 by passing a royal charter, and several people, they started establishing companies, and they are collecting money. Nowadays also we are seeing, and they are disappearing, these companies. That's why to control these these companies, Bubbles Act 1720, it passed, and it prohibits companies, it prohibits all persons to create companies till 1824. After 1824, this Bubble Act they repeat, and Parliament started giving power to the people to establish companies. And the first act in England is Joint Stock Companies Act 1844. In England, first act was passed regulating companies 1844. This particular act gave separate personality concept. The company is a separate person once it is registered under the Companies Act. That concept was recognized in 1844. But limited, one of the main advantages of doing business in the form of company is limited liability. But limited liability concept was not recognized till 1855. In 1855 in England, they passed a Limited Liability Act 1855. This act gave right to the company to do business with limited liability. So this is another advantage of doing business in the form of limited liability. Here I want to tell one example. There is one English judge, he identified this particular concept, limited liability. Because of him, today companies are able to attract huge funds. He was so enthusiastic for this word limited. He executed a will before his death, and in that will he requested his heirs, when anyhow you construct a tombstone on my in graveyard. So when you construct a tombstone, date of birth, date of death, you write within brackets, write limited. If you go and see his Lord Bramwell, he identified the principle limited liability. If you go to London and see his tombstone, we can see the word limited on his tombstone. So we can say he was the father of company law. And then this 1844 Act was repealed, and they passed 1856 Act. This act they considered to be modern company law in those days. And this 1856 Act also was repealed by 1862 Act. English Companies Act 1862 was repealed by 1908 Act. English Companies Act 1908 was repealed by English Companies Act 1929. English Companies Act 1929 was repealed by English Companies Act 1948. English Companies Act 1948 was repealed by English Companies Act 1985. When I asked any student, even today in Assam, NLU Assam or MNLU Aurangabad, or in some places, first act was passed in which year? Companies Act. They are telling 56 Act. 1956. But 1956 is not the first act. First act was 1844 in England. And this English Companies Act 1985 was repealed by English Companies Act 2006. Now, it came into force in 2009 in England. So, English Companies Act 2006 in England, they are following now. This is about the history of English company law. Now, let us come to Indian company law history. First, they passed in the year in England 1844. In India, first act was passed, Joint Stock Companies Act 1850. 1844 Act, 1850. If you see, it is nothing but photocopy of 1844 Act. As it is simply only heading they removed. English Companies Act removed and they kept Indian Companies Act. Then onwards, 1850 Act in India was repealed by Joint Stock Companies Act 1857. Till 1857, separate personality was not recognized in India. In India, company was not having separate personality. Only 1857 Act recognized separate personality concept. And 1857 Act was repealed by Companies Act 1866. Companies Act 1866 Act was repealed by Companies Act 1913. 1913 Act was amended drastically in 1936, and that was almost, it changed the Companies Act, but it was called Amendment Act only. But almost we can treat it as a new law, 1936 amendment. The Companies Act 1956 replaced the Companies Act 1913. So if you see 56 Act and if you see English Companies Act 1948, these two are photocopies. That's why Sahare, who wrote a book on English, who wrote a book on company law, in his introduction, he said, our Indian Companies Act or any other act, Indian Act, they are the most cherished children of English brains. Means simply whatever laws they are passing in the British Parliament, we are bringing those and we are simply copying and passing in Indian Parliament. That's why Sahara said like that. And with reference to this 56 Act, they have 1985 Act. Once they passed 1985 Act, we wanted to repeal 56 Act. And we wanted to pass on same lines, 85 Act. But they were unable to, pass that. And 56 Act is based on Baba Committee report. Baba, he prepared the report. On the basis of that, they prepared this Companies Act 56. And when P.V. Narasimha Rao became Prime Minister, he made several reforms. Then they made so many changes in laws. Labor laws, they changed, and all commercial laws, they changed. They wanted to change. Similarly, Companies Act also, they wanted to change. And they prepared Companies Bill 1993. It was not passed because at that time, the Prime Minister, P.V. Narasimha Rao, was not having majority in Rajya Sabha. They were unable to pass in Rajya Sabha. It remains as a bill. Then Companies Bill 1997, then also the government was not having absolute majority. That bill remains as a bill. Companies Bill 1997. Then the government prepared a concept paper in 2000 by making all changes in company law. And then Companies Bill 2008, they prepared. And meanwhile, they appointed one committee called Irani Committee. That Irani, who is this Irani? He is a scientist, and he joined as a scientist in Tata Group, and he became CMD and chairman of Tata Group, and he is a scientist. And our government asked a scientist to prepare a report for passing this new law. And he prepared and submitted a report to the government. And on the basis of that, they prepared all these bills, Company Bill 2008. Then, with great difficulty, when Rajesh Pilot was the Corporate Affairs Minister during Congress government, they passed this act, Companies Act 2013. And if you see 2013 Act and English Companies Act 2006, till 1948 till 1956, Companies Act almost we copied, we followed. 1985 Act also we failed to follow because of lack of majority in what you call Parliament. But English Companies Act, what they did, 1985 Act, English Companies Act consists of 650 sections like that, odd sections. And in 2006, they doubled the sections, 1300 sections in England. But in India, our Companies Act 1956, if you take, it consists of 658 sections. But if you see 2013, they reduced to 470. So here we made a drastic change when compared to English law. English law 1300, Indian law only 470. But majority criticism is the jurists they criticized, instead of expanding, they clubbed 4 to 5 sections into one sections and provisos like that they added, like that they criticized. And one more important change between 56 and what you call 2013, Companies Act 1956 is self-contained. You need not refer any other act. You need not refer any other what you call regulations, rules, all these. If you read Companies Act thoroughly, that is a classic one, and everything is discussed in Companies Act only. But whereas if you take Companies Act 2013, Companies Act consists of 2013 consists of 470 sections. More than 370 sections are ended with as may be prescribed. As may be prescribed means rule making power. As may be prescribed, 370 sections are ended with as may be prescribed. As may be prescribed means rule making. What is the difference between rule, regulation, and act? Act is passed in the parliament, whereas rules are framed by the Ministry of Corporate Affairs, Companies Act, Ministry of Labor, Labor Laws, Ministry of Finance, Central Board of Direct Taxes will prepare rules for Income Tax Act, GST Council, GST Act, Ministry of Finance, they will prepare what we call the rules for GST. And regulations are prepared by the statutory body. For example, RBI regulations, SBI regulations. Our universities, we are framing so many examination, hostel, all this we are calling rules. In several universities I am seeing, even in some national law schools also, they are calling rules. These are not rules. Ours is a statutory body. So we have to call it as a regulation, examination regulations, or hostel regulations, moot court committee regulations, like that regulations. Once it is approved in Executive Council and General Council, Academic Council, these are called regulations. Similarly, when statutory body, when it prepares, these are called regulations. Now, to understand what you call this commercial law till 2000, teaching commercial law, teaching corporate law, banking, insurance, all these are very, very easy. But now, teaching any economic law, corporate law, taxation, or what you call insurance, banking, very, very difficult, because we have to go through sections, we have to go through rules, we have to go through regulations, all these club together, we have to teach the student. When we practice, we have to club all these and we have to practice. So now it is very, very difficult to teach and very, very difficult to practice also these economic laws, acts, rules, and regulations. And out of 470 sections, 370 sections are ended with rules. So whenever we teach incorporation, sections, 1 or 2 sections will be there. Rules we have to take. And when we teach directors, rules are there. Those rules we have to teach. So along with sections, rules also we have to teach. Otherwise, it is difficult for student to understand and practitioners to practice. So this is one important change they made. Till 1956, what you call till 2013, we had another act also, Securities Contract Regulation Act 1956. And Companies Act, what we call, if you take, company means what? company is defined in Companies Act as any company registered under this act is called company. Any company registered under this act is called company. That is the definition given by the framers of the code. Now, these companies you can classify into two types. What are those? Private company and a public company. Private company, what is private company? A company which by its articles of association, articles means every company has two fundamental documents, memorandum of association and articles of association. Memorandum of association defines the powers of the company. Articles of association defines the powers of officers of the company. Memorandum of association is like a charter of the company. Articles are nothing but bylaws of the company. In articles of association of that company, the promoter should add three restrictions. What are those? A company which by its articles of association limits the number of its members to 50. Under Companies Act 50. Now it is 200. In private company, minimum is 2 and maximum is 200. And the second condition is prohibits the issue of prospectus to the public. A company, private company cannot allot shares by issuing prospectus to general public. And third one, restrict the right to transfer its shares to the general public. Shares are not transferable freely. Shares are transferable, but in private company, first the shareholders should offer to other shareholders, existing shareholders, only when they refuse, then he can offer to the outsider. So when these three restrictions are there, it is called a private company. And a public company, they defined in a simple way, any company which is not a private company is called a public company. So in public company means these three restrictions are not there. That is called public company. And every company has two corporate securities, shares and debentures. And shareholder is only an investor. He is not the owner of the company. When we ask anyone who is the owner of Reliance means Ambani, who is the owner of Infosys means they tell what you call Narayana Murthy. No, Narayana Murthy and Ambani, they are only investors, shareholders. The real owner is company itself, real separate personality concept, Salman versus Salman and company. So, shareholders are only investors and debenture holders are only creditors. They are entitled to claim only dividend. They are entitled to claim only interest. Shareholders are entitled to claim only dividend. Again, preference shareholders and equity shareholders, two types of shares are there. Preference shareholders are having very limited voting rights. Equity shareholders are having wider voting rights. All policy decisions will be taken by the equity shareholders with voting right only. In 2000, again they classified equity shares with two types: equity shares with voting rights, equity shares without voting rights. Without voting rights means he has no right to participate in taking decisions of the company. So, like this, these what you call restrictions. So, the Securities Contract Regulation Act 1956, what you call is dealing with these securities. Whenever the company wants to issue any shares, debentures, all these are regulated by Securities Contract Regulation Act. Mainly, it is dealing with stock exchanges. Stock exchanges till 2004, they were societies registered under Societies Registration Act. And trading was done by the society members and complete control was done by the directors were society members and capital also was held by the society members. All three are in one person only. And these societies, all these Bombay Stock Exchange, Madras Stock Exchange, Calcutta Stock, all these were societies registered under Societies Registration Act. And whenever the company wants to list its shares, listing was optional. Till 2000, till 1988, listing of securities was optional with stock exchange. If the company wants to list, it can. Otherwise, it need not list its shares with any stock exchange. But Companies Amendment Act 1988 made listing compulsory. Whenever any company wants to issue, again, in 1992, what you call SEBI Act, the government passed, Securities Exchange Board of India Act. And the SEBI Act, what you call, main object of SEBI Act 1992 is to protect the interest of investors in corporate securities. And the SEBI Act classified public companies into two types: widely held public company, closely held public company. Closely held public company means A public company was entitled to issue prospectus and what you call collect allot shares debentures to the general public. But it was not compulsory for public company to issue prospectus. If they want to raise capital debentures without issuing prospectus, the public company can raise. So when it allot shares and debentures without issuing prospectus to general public, it was called closely held public company. When the company wants to issue prospectus and allot shares and debentures, when it wants to raise funds by issuing shares and debentures to general public by issuing prospectus, that is called widely held public company. Companies Amendment Act 1988 made listing compulsory, and SEBI Act also classified public companies into closely held and widely held. And this widely held public companies, whenever it wants to raise capital by issuing prospectus to the public, SEBI says it must apply to at least one recognized stock exchange for listing its shares. When it, according to what you call Kolkata Stock Exchange Association case, when the company applies to 5 stock exchanges, it must obtain permission from all 5. When company applies to 20 stock exchanges, it must obtain permission from all 20 stock exchanges. Even one stock exchange refused permission, entire allotment was void, according to Supreme Court decision. So this SEBI Act and 1988 Amendment Act made listing compulsory of widely held public companies. When Dhirubhai Ambani in 1980s, when he started the business, he issued a prospectus. Prospectus was oversubscribed hundreds of times. He did not invest single NP. He was a penniless. He was not having money, but he issued. But he developed some reputation, and with the public money, he started the business. And with what you call with reference to LML scooters also, 83 they issued prospectus. Prospectus was oversubscribed. 88 they started production, and without investing single NP, these promoters, they collected money from general public and they started, they did business. So the SEBI Act says listing is compulsory, and this SEBI Act, it prescribes so many what we call stringent conditions for issuing prospectus. From SEBI Act was passed in 1992. 1992 to 2000, SEBI issued so many guidelines. These guidelines were scattered for relating to what you call regulating capital markets. For issuing prospectus, the company has to fulfill some norms. It should get certificate of incorporation. Then after that, it should get certificate of commencement of business. Then it should do business for minimum 5 years. Out of 5 years, 3 years, it should earn profits. The net worth of the company must be this much. Like that, so many conditions, what you call these guidelines, SEBI guidelines, they prescribed. But these guidelines were scattered, difficult for company secretaries, chartered accountants, lawyers, and students, teachers to go through all these. And one more problem, rules and regulations are enforceable, guidelines are not enforceable. In case anyone violates the guidelines issued by anyone, government also, guidelines cannot be enforced in the court of law. That is only a guideline. But if you see, on 11th June, first time when they passed the guideline, 11th June 1992, if you see, the SEBI says, if anyone violates the guideline, SEBI can institute criminal proceedings. How SEBI can institute criminal proceedings for violation of guideline? Because these guidelines, they are never placed before Parliament for Parliament assent. Whereas rules and regulations, they are supposed to place before Parliament when it is in session for 60 days. So later on, they omitted that guideline, and in order to avoid this problem, they passed what you call the regulations. They converted all these guidelines, SEBI Disclosure and Investor Protection Guidelines 2000. They consolidated all these guidelines and they divided into chapters. But these guidelines are not enforceable. So they converted these guidelines into regulations. SEBI Issue of Capital and Disclosure Requirement Regulations 2008. And regulation is violated, then it is an offense, and SEBI can institute criminal proceedings against the violator. And these regulations 2008 were repealed by SEBI Issue of Capital and Disclosure Requirement Regulations 2018. It was last amended on May 17, 2024. So now any public company wants to issue what you call prospectus and allot shares and debentures to general public, it has to fulfill the conditions prescribed by what you call SEBI Issue of Capital and Disclosure Requirement Regulations 2018. And the SEBI discussed so many other intermediaries also. Now, when a company wants to before 2000 what you call 8, when a company wants to offer shares directly, it was offering, it was not appointing any intermediary. But now there is a link between these intermediaries, are the link between company and investor. Any company, before issuing prospectus to general public, it has to appoint so many intermediaries. Who are these intermediaries? What you call mutual funds, there is an intermediary. Whenever anyone wants to do mutual fund business, they have to register under mutual fund regulations. Brokers, sub-brokers, banker to an issue. Someone should deal on behalf of the company with banks. So banker to an issue, credit rating agency. Like our NIRF ranking, companies also should obtain rating from these credit rating agencies. These agencies have to register. Anyone wants to act as a credit rating agent, he has to, or it has to register under SEBI. Then custodian of securities, derivatives. When you are doing derivatives, you need not hold any debentures. Without holding debenture shares also, you can do derivative business. For that, there must be some intermediary to hold debentures. So custodian of securities, it is one intermediary. Debenture trustees, all these debentures are in the name of one trustee. Who is the trustee? Anyone can act as a trustee, but he has to register under SEBI. He is one intermediary. Depository and depository participants. That is, all shares must be allotted in electronic form. So there are two depositories today, NSDL and CDS. And these two, what you call, company should appoint as its depository. And through this depository only, company has to allot shares or debentures in demat form, electronic form, to the debenture holders or what you call shareholders. And this is there are those two depositories are Central Depository Services Limited and National Securities Depository Limited. And foreign venture capital investors, on behalf of foreigners, venture capital business, if they want to do, anyone can register and as a foreign venture capital investor, and through him foreigners can do venture capital business. And investment advisors, so many persons are advising the public on investment. He is also intermediary, he has to register with SEBI. Infrastructure investment trust, with reference to infrastructures also, when any entity, individual or company or a what you call firm wants to raise funds, it has to register with SEBI Infrastructure Investment Trust. Then merchant banker, whole public issue, the company should handle through merchant banker. If it all depends on the issue size. If issue is 1 crore, one merchant banker, 5 crores, two merchant bankers, like that, SEBI prescribed. And who is this merchant banker? Any bank can act as SBI, any bank, HDFC. These bankers only are acting as merchant bankers. And registered mutual funds, portfolio managers. Portfolio managers means these persons are we can give our money. If you don't have money, if you don't have time but we have money, then we can approach any portfolio manager. You invest my money in so and so securities, like that. That person is called portfolio manager. If anyone wants to do this business, doing business for some other persons, that is called portfolio manager. He is also an intermediary. He has to register with SEBI. Similarly, if the company, if shareholder wants to transfer shares, if company wants to allow the shareholders to transfer their shares, it has to previously directly shareholders were transferring their shares to outside some other person. But now that is not possible. The company is appointing share transfer agent. Through that share transfer agent only, shareholders have to deal with. Then register to an issue means he will administer through merchant banker total public issue, and this is what you call one intermediary. registered valuers. At the time of mergers and acquisitions, valuation of shares, valuation of properties of the company should be done. Like in insurance, at the time of when vehicles are damaged, valuers will come and assess the loss. Like that, companies also what you call are allowing the valuers to do practice, and they have to register. This list is only illustrative whatever I said. This is not exhaustive. And these are called intermediaries. Every company, when it wants to issue prospectus, when it wants to raise funds, it has to appoint all these intermediaries. Through intermediaries only, company should do the business. Similarly, insurance company also, all these so many intermediaries are there. Insurance company also must what you call do its business by appointing intermediaries recognized under IRDA Act. Then, with reference to this shares, till 1996, companies were allotting shares in paper document form. Till now, we were getting all our degree certificates. We are issuing degree certificates paper document form. Now, DigiLocker, UGC recognized. In electronic form, DMAT form, degree certificate, mark certificate, everything. For that, every time they need not approach the university. If they apply to that UGC, that particular DigiLocker, they can get any number of certificates. So shares and debentures also must be offered through, because document form, paper document, difficult to what you call preserve. So what they did, they passed Depositories Act 1996, and this Depositories Act, what you call, insists that whenever a company wants to issue till 2013, when the capital is more than 10 lakhs, then only shares and debentures should be allotted in DMAT form. Like that condition was there. But 2013 Act says issue of share, one share also, the company must allot only in electronic form. This is what's called Depositories Act 1996. Now, this securitization, stock exchanges, they amended Securities Contract Regulation Act in 2003, and demutualization, what you call, they did. Means what they did, the government amended the act and said all societies must be converted into companies. That too public companies, that too listed companies. All companies must issue registered, that is stock exchanges I am telling. All stock exchanges, societies must be converted into companies, that too public companies, that too listed public companies. And they have to issue prospectus. More than 51% shares it must offer to general public. And directors must be shareholders, not the investors. So management is segregated, investment is segregated, and policy decisions also can be taken by the directors of the company, and issue of shares also more than 51%. And what you call the society's concept was what you call repeat, and now all stock exchanges, they are listed companies, and their shares also, debentures also can be traded in stock exchanges. And they can establish board of directors with independent members, improving corporate governance. Capital can be raised by issuing prospectus. These are some additional changes in Securities Contract Regulation Act with reference to stock exchanges. Am I audible? Okay. And with reference to what you call company law board, till 2013, we were having company law board. In addition of what you call board of directors, the aggrieved party was preferring an appeal to company law board. And the company law board was head office is in Delhi, and regional office Madras, Bombay, and Calcutta were there. And company law board decision was final when there was a dispute between company and an investor. Against the decision of company law board, appeal lies to Supreme Court only on question of law. But with reference to winding up of companies, we have Board for Industrial and Financial Reconstruction was a development finance institution under the ownership of Ministry of Finance, Government of India, part of the Department of Financial Services of the Ministry of Finance. It was set up in 1987, BIFR, and against the decisions of BIFR, AIFR, appeal against Board of Industrial Finance, Financial Reconstruction. Whenever a company becomes sick, any possibility is there to revive that or not. the creditors and debt shareholders company can refer it to BAFR. Any possibility is there? BAFR was giving some suggestions, some schemes, and by following those schemes, instead of winding up, the company was giving some, BFR was giving some what you call relief to the companies. But suppose any party is aggrieved against the decision, he can prefer an appeal to AIFR. Against the decision of AIFR, appeal lies to Supreme Court. But these bodies, Company Law Board and BAFR, AIFR, all these were repealed once 2013 Act was passed, and in the place of BAFR, in the place of CLB, they established NCLT, National Company Law Tribunal, and National Company Law Appellate Tribunal. National Company Law Tribunal is situated in almost every states. In some states, 2-3 benches are also there. Now, dispute between shareholders, debenture holders, investors, company, they have to approach NCLT. Against decision of NCLT, appeal lies to NCLAT, National Company Law Appellate Tribunal, and against decision of National Company Law Appellate Tribunal, appeal lies to Supreme Court. So, now with reference to CLB, all matters relating to companies should not be even mergers, acquisitions, winding up. Everything will go to NCLT only. Before that, courts were what you call dealing with winding up matters, but now that power is also shifted to what you call NCLT. Now, with reference to Securities Appellate Tribunal, Securities Appellate Tribunal is there. It was established under Section 11C of SEBI Act. That is, under SEBI Act, any difference are there, disputes are there between company and outsider. That particular dispute should be resolved by Securities Appellate Tribunal, which is situated in Mumbai. In addition of Securities Appellate Tribunal, appeal lies to Supreme Court at one time, but now again High Court, they have changed, and High Court to Supreme Court. So this is one change with reference to Securities Appellate Tribunal, High Court, Supreme Court. This under SEBI Act, this authority was there. Then this is under Section 15K of SEBI Act. Then the Administration of Companies Act. Overall administration is vested with central government. At one time, there was only Department of Company Affairs. There is no department, there is no separate Ministry of Corporate Affairs. And this Department of Company Affairs only was dealing with what you call company secretary, Department of Company Affairs. And it was attached to Ministry of Finance, sometimes Ministry of Labor, Ministry of what you call industry, like the different departments it was attaching. But after 2013, Modi government created Ministry of Company Affairs and Ministry of what you call Company Affairs. First time they created, they converted this Ministry of Company Affairs into Ministry of Corporate Affairs in 2008. 2003 they created, and after 2003 only they created Ministry of Company Affairs. They converted this into, after Companies Act 2013, Corporate Affairs. What is the difference between company law and corporate law? Company law means only Companies Act. Corporate law means SEBI, then Competition Act, FEMA, all these will come under what you call together. We can call it as corporate law. And with this is about what you call Administration of Companies Act. And total country is divided into 5 regions. Each region, southern, northern, eastern, like that, each region is headed by one regional director, and every state is controlled by one registrar of companies. So all these authorities were controlling total Administration of Companies Act. And SEBI passed one insider trading regulations in 1997 only, insider trading. The persons, directors or shareholders, or the persons who are having touch with accounts, they know, they will come to know well in advance. Next financial year, whether company earned huge profits or not. Once they declare huge profits, automatically share value will increase. The insider is having this information. So he may purchase shares from general public without disclosing this information. And it is nothing but a fraud on the public. So they pass this insider trading regulations. This insider should not deal with what you call company securities till the unpublished information is published in general public. And it is an offense, first time, punishable with monetary penalty, If penalty is not paid, imprisonment also courts can impose. This is one latest. And under the new Companies Act, they created one-man company. Company means two persons, two or more persons. But one-person company they created. How they come? One side they are saying that it is a company. Company means association of persons. Company means companies. Come means with or together. Panis means bread sharer. Companies means bread sharer, breadwinner. Company means more than one. It implies. But one person company, it is like marriage. One person marriage. If it is one person marriage is recognized, then why not? One person company. One person company also they recognize, but he has to nominate in articles in case of his death. Someone should take hold of that company. Who is that person? He has to write. One person company they recognize. So many companies, so many persons are establishing one person companies now. It is outlawed all those public companies and private companies now. This private company is also classified into small company. There is another concept they introduced in 2013 when the capital issued capital is less than what you call 20 to 20 lakhs, like that, 20 lakhs to 50 lakhs minimum, then that is called a small company. So many exemptions are given to that small company. And in 2008, Limited Liability Partnership Act they passed. What is this Limited Liability Partnership Act? Normally, advocates cannot do what you call profession with chartered accountants, company secretaries. In England, to join hands with other professions, they passed this Limited Liability Partnership Act in England 2000. Under that, professionals can register and they can do what you call their profession. They can exercise their profession. CA, cost accountant, company secretary, lawyer, valuers, engineers, all these they can join, register under limited liability, but they can. Initially in India also, they said it is meant for professionals. Now they extend it for general trade also. Anyone can do trade also, selling goods and selling services. And with reference to this, what you call insolvency, when the company becomes insolvent, normally company courts were dealing and liquidator was administering the affairs of the company business, and official liquidator was there. But this official liquidator and liquidator both were abolished by after passing Insolvency and Bankruptcy Code 2016, because this act recognized insolvency resolution professionals. If anyone passes that exam and start this particular insolvency resolution professional, like lawyers, chartered accountants, if one good company, Bhushan Steels, if X is appointed as insolvency resolution professional, his commission is in crores. Like that, if MNCs or big companies become insolvent, then insolvency resolution professional can earn more. Then these insolvency resolution professionals were regulated by bankruptcy board, and now total what you call insolvency, winding up proceedings, everything is transferred to what you call insolvency and bankruptcy code, winding up of companies. That portion is omitted from Companies Act. This is one important change we have to. And whenever any foreigners, now after SEBI came ADR, IDR, and GDR, global issues, Euro issues, Indian companies can go for Euro issue, all this. Then America, the companies can allot shares, issue prospectus, and to Americans, they can. Those are called ADR, American Depository Receipts. All these, when they are dealing, they have to follow FEMA, Foreign Exchange Management Act 2002, they have to, and RBI permission they have to obtain. And without following FEMA, they can't deal with foreigners. They can't allot shares or debentures to foreigners. So FEMA Act is very, very important. Before this, FERA was there, Foreign Exchange Regulation Act 1947. This act is repealed by Foreign Exchange Management Act 1999. And under FERA, everything was prohibited unless permitted. Under FEMA, everything is permitted unless prohibited. And so many what you call offenses, they converted into what you call fines. That too, not fine under IPC, it is monetary penalties only. So they simplified these laws, economic laws now. And one more, suppose there are some companies which are doing business to cheat the public, and serious cases, huge capital frauds are involved. then central government constituted a what you call office called Serious Fraud Investigation Office under Companies Act. One can approach, one can give a complaint to Serious Fraud Investigation Office for capital frauds by the companies. And already we discussed that in the place of liquidators, insolvency resolution professionals, in the place of official liquidator, bankruptcy board came into picture. And with reference to foreign trade, if you want to export, import, in addition to Companies Act, we have to follow Foreign Trade Development Regulation Act 1992. If you want to import or if you want to export, we have to register as exporter or importer or for Foreign Trade Development Regulation Act. And money laundering, that is, companies are violating by what you call illegal transfer of money from India to some other. When they are transferring this, money laundering also came into picture to take action against the serious. And with reference to banking companies, when they give loans to the individuals or companies, when it becomes a non-performance asset, two acts they passed. SURFACE Act 2002, that is Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, and Debt Recovery Tribunals Act also. Under this act, the banks will issue notice. They need not go to courts, civil courts. Civil courts means it takes time. If they go to Debt Recovery Tribunal or the Debt Recovery Appellate Tribunal, once it is proved that it is a non-performance asset, the power is given to the bank to sell the property. This is one latest economic law for banking companies. Now, Foreign Contribution Regulation Act. If you take any contributions from foreigners, Foreign Contribution Regulation Act 2010, Jayalalitha claimed that she received so many contributions, gifts from foreigners, and she did not follow this Foreign Contribution Regulation Act. And under this act, she was prosecuted. So whenever we receive any gifts from foreigners, we have to follow the conditions prescribed in Foreign Contribution Regulation Act, and same principle is applicable to companies also. And with reference to before that, cross-border mergers was not allowed, but 2013 Act permitted cross-border mergers. That is, an Indian company can acquire a foreign company. For that, 234 of Companies Act is dealing with cross-border mergers. And Companies Act introduced one new concept, CSR, Corporate Social Responsibility, 135 to 138 of Companies Act 2013. This is 2% of net profits. When the company fulfills some conditions prescribed on 135, it has to spend 2% of net profits for the what you call points mentioned in Schedule 7 of Companies Act, education, health, like that. They mentioned for those purposes they can. And another act is there relating to companies, Micro, Small and Medium Enterprises Act 2006. And those, it may be what you call a individual firm or a company. And when they do business in the form of with small amounts of capital, they can register under Micro, Small and Medium Enterprises Act 2006. They get lot of exemptions, benefits under this particular act. So if a person wants to do business. And another act is Consumer Protection Act also is giving some protection to the what you call consumers when companies are exploiting the consumers. And Competition Act also is protecting the consumers. The main object of both Competition Act, Consumer Protection Act is to protect the interest of consumers and against giants. Mainly, Consumer Protection Act is applicable to small fishes traders. Competition Act is applicable to what you call whales, big companies, all this. And with reference to mergers and acquisitions, when the threshold is more than a particular limit, then what you call the companies have to obtain permission from NCLT and what you call Competition Commission also. Without obtaining permission from Competition Commission, that merger or combination is not permitted. So already 4-5. Thank you for giving this opportunity.